Welcome everyone to the Savvy Ladies Wednesday Wisdom webinar. I'm Maggie Montemuro and I'm the Marketing Manager at Savvy Ladies. I would like to remind you that if you have any questions during the webinar, you can type them into the chat box or email info@savvyladies.org. Today's presenter is Susan Rothwell, a trusts and estates and tax attorney with over 20 years of experience in sophisticated estate planning and administration of estates. She advises clients on estate and tax planning for wealth preservation, assists clients with gifting, asset protection, and transferring wealth to future generations. She prepares wills, trusts, prenuptial agreements, and other vehicles to help clients achieve their goals. She received her Master of Laws from New York University and her JD and MBA from Columbia. Thank you for being with us today, Sue, and I'll hand it over to you.
Okay, thank you, Maggie. So today I'm going to talk about why you need a will. How many of you don't have a will? Polls suggest that more than half of you don't have one. Or if you do have a will, have you looked at it recently? Maybe you have kids now. Maybe you feel differently about the people you've named as beneficiaries. Maybe you've gotten divorced. Maybe you're living with someone else or you're remarried. Whenever major changes take place in your life, you should go back and review your will to see if you need to make changes. How many would like to have a will but think you have plenty of time to get one? You don't have to be rich, famous, or elderly to need a will. Unfortunately, ordinary people, as well as celebrities, die unexpectedly at all different ages. Look at the performer and singer Prince, who died last month without a will. His estate will probably be stuck in court for many years to come. And it could have been avoided if he had had an effective will. Did you know that by not having a will, the state's law where you live determines who gets your property with their one-size-fits-all provision, known as the law of intestacy? I'll come back to that. But first, what is the purpose of an effective will? It enables you to control who receives your property after you die. It leaves a set of instructions for who gets your property and under what conditions. It enables you to appoint someone that you trust, called an executor in New York, or a personal representative in some states, to be in charge. That's the person who's responsible for carrying out the instructions in your will. Besides the obvious benefit of providing economic support to a loved one, a will frequently can provide solutions or even quasi-interventions in emotionally fraught circumstances. What if you're a single parent with minor children and you die suddenly? What if you have a loved one who's a drug addict or an alcoholic, or a person who's just unable to manage money? I'm going to show you how a will can help you provide support to the people you care about when they're coping with some of these difficult situations. If you have minor children and something happens to you, obviously you don't want just anybody to be responsible for them or to have control over any money you might leave them. If you don't have a will, you're leaving these decisions up to a court. The court is going to select a guardian, and it may be someone you can't stand, like your ex who's an alcoholic or some other unsuitable person. A will enables you to name the guardian. And this is such an important decision that it can actually be a stumbling block to completing a will. People procrastinate because they can't decide who to select. But remember, whoever you select is probably preferable to who a court would select. And you can always change the guardian over time, either by writing a codicil to your will, which is like an addendum, or just by updating your will with a new one. Don't let indecision about who to appoint as a guardian get in the way of completing a will. Under a plain will, your assets get paid out to your beneficiaries all at once. But there are situations where it's helpful to distribute funds to your beneficiaries over time and under certain conditions. And there's a way to do this by adding trust provisions to your will. You name a trusted person to be in charge, called the trustee, who follows your instructions in the trust section of your will about how much to distribute to your beneficiaries, how frequently, and under what conditions. Here's an example of how it works. If you have minor children, obviously you wouldn't want them to receive your assets outright. To avoid this, you can set up a trust under your will for the benefit of the minor children. That way, if something happens to you, you've specified how much of your assets you wish to put aside in trust, you've selected the person to be in charge, the trustee, and you've left instructions on how and when your trustee makes the funds available to or for your children. You pick the trustee, and you can therefore select a person that you trust, a person who thinks like you and shares your values, and you can have discussions with that person on when and what you'd like to have happen. For example, you can share your philosophy about what ages your kid should receive the principal of the trust. Do you want your child to have your assets at age 18, or do you want to wait until the child is older, say 35? Do you want to put conditions on receiving the assets, such as upon graduation from an accredited college? Do you want to instruct your trustee to withhold funds if, for example, your child is having a drug or alcohol problem? In short, you can give the trustee a lot of independent power to make decisions based on the circumstances at that time, or you can give the trustee limited power for discretion and instruct him to follow a formula in distributing funds to your children. Another situation in which trust under a will can be very helpful is in dealing with complications from a second marriage. If you have children from a first marriage, a trust can protect their inheritance. Generally, when spouses draft wills, they try to take care of each other first before distributing their assets to other beneficiaries. However, if you were to leave everything to your spouse, he or she might decide that he has other priorities than leaving any of that money to the kids from your first marriage. A common way of managing this is to leave funds in trust for your current spouse during his or her life rather than giving them outright. You can control how much your spouse will receive from the trust, and on the spouse's death, the trust terminates, and the remainder of the trust gets paid to your children from your first marriage. Even if your current spouse isn't happy about the arrangement, this can provide some protection to children of your first marriage. Another emotional situation you can deal with using a trust under a will is caring for family members who receive government support, or beneficiaries who are receiving government support such as Medicaid or disability payments. Remember, Medicaid is for people who either have very little money or who have depleted their assets. It pays for medical care or nursing home care for eligible people. There are thresholds of income and assets in order to qualify. A trust under a will enables you to protect that person's governmental support by using a special trust called a special needs trust. The trustee is instructed to distribute the funds to pay for expenses of the beneficiary or provide cash in such a way that the beneficiary does not get disqualified and kicked off the benefits. You may also have a gambler or someone in your family who just has problems managing money among the people you care about. A trust may also be used to protect that person by enabling a trustee to control the person's access to funds. That way the funds won't get depleted all at once and can provide a means of support to the person over time. Now I'm going to talk about how you can protect someone from a divorce. Maybe your daughter's married to a serial philanderer who likes to brag about what a great lawyer he is. Maybe your daughter, or more likely her spouse, have potential creditors. Did you know that if you leave your assets in a trust under a will for the people you care about, rather than giving them outright on your death, you can protect a married daughter, for example, from a divorcing spouse or from potential creditors, because the money is locked up in the trust and outside of the control of the beneficiary. so you can insulate the money you leave from your son-in-law if he ends up divorcing your daughter, or vice versa, and shield her from creditors if they stay together. In other words, you can make sure that funds that you intended for your daughter really go to her. And I'm going to give you one more example of a trust under a will. Pet trusts. Now, some of you may think this is a joke, but for those of you who have pets and love them, you know this is a real issue. How to take care of them after you're gone. If you're not from New York, you may not remember Leona Helmsley, who inherited a real estate fortune worth billions and was known as the Queen of Mean. One of her well-known quotes was, "Taxes are for the little people." And she went on to be convicted of tax evasion and put in jail. After she got out, she got a dog and named it Trouble. That's a picture of Trouble and Leona on the right of your screen. She left $12 million to Trouble in a pet trust under her will. But you don't need $12 million to set up a trust that will provide for your pet. So all of these things that I've been talking about can be managed and successfully accomplished by having a will. Without a will, none of these things can be accomplished. Now I'm going to talk a little bit about estate taxes, because having a will and doing some estate planning while you're young may help you minimize your estate taxes. This will only affect you if you're lucky enough to have a taxable estate at the time of your death, and of course, unlucky enough to die. This year, you need to have more than $5,450,000 to have a taxable estate for federal estate taxes. Or for married couples, that amount is $10,900,000. But first, what is your taxable estate? It includes all the assets that are in your name when you die, including furniture, jewelry, cars, bank and investment accounts, real property, insurance and retirement accounts. It includes investment property and partnership interests. Your taxable estate also includes your debts, like credit card debt and a mortgage, which are subtracted from the value of your estate. If you happen to die in an up market, your investment property may be more valuable than you realize. If you have a taxable estate, a will also enables you to instruct your executor about how to pay the estate taxes. Amounts above $5.5 million are taxed on a graduated scale that goes up to 40%. Most states also have their own estate taxes and thresholds over which your assets are subject to tax. In New York, where I live, you can shelter a little more than $4 million from state estate tax, and the rate of tax goes up to 16%. So the combination of federal and state estate taxes can lead to taxes in excess of 50%. So if you have a taxable estate, having a will and doing your estate planning early may enable you to minimize your estate taxes, but some of those details are beyond the scope of this talk. Now I'm finished talking about estate taxes, and I'm going to talk about what happens when you die intestate, which means dying without a will. I'm going to take you through some of the mechanical and legal steps that need to be taken. When you die without a will, you've left no instructions on who should inherit your property. You've left no one in charge of your estate. If you have minor children or dependents, you haven't provided for who will take care of them and manage their finances until they become adults. This is where the state will comes in. The state where you live will have a law that decides who gets everything with their one-size-fits-all remedy. Whatever combination of relatives you're survived by, your state's law provides which relatives inherit and how much. Here's an example of what would happen in New York under 3 scenarios. You don't have a will, you're survived by your live-in boyfriend or girlfriend, who you're not married to, and one relative who's a parent. Under New York State's formula, everything will go to your parent. What if you're survived by a grandparent and the unmarried live-in boyfriend or girlfriend? Then everything will go to the grandparent. And finally, what if you're survived by the unmarried live-in boyfriend or girlfriend and you have no relatives? Then all of your property is going to go to the state. So if you live in New York, Governor Cuomo will get all of your property. The court is also going to select and appoint someone to be in charge of your estate, called an administrator. And that administrator will be paid out of your funds from the estate. So think about this. You've died suddenly without a will. Your family and friends are together after your funeral, and somebody asks, what now? Who's responsible for your debts, your belongings and property? Who can get into your apartment? Where do they start? Who can they go to get help from? Don't leave the people you care about with this additional burden of figuring out what has to happen next. They're vulnerable at a moment like this, and you don't want some bully like your hated son-in-law from the prior example to step in and take over. Here's some of the things that would actually happen. First, all the property that you hold in your own name is frozen. No one, no family member, no friend has the legal power to do anything with your assets. So no one can pay your bills, your insurance, your monthly mortgage, or your taxes. Someone, probably a family member, will have to step up and pay for the funeral and the initial legal fees and wait to be reimbursed after the court appoints someone to be in charge. In order to access your assets, a family member, if there is one, or if not, perhaps a creditor, will have to take it on themselves to petition the court in charge of wills, trusts, and estate matters to get themselves appointed as the person legally in charge of your estate. That person will require an attorney to draw up the legal papers for the court. If the court accepts the person's petition, he or she will be appointed the administrator of the estate. He or she will then have the same responsibilities for managing your estate as the executor appointed under a will. The difference is that without a will, the court appoints this person. With a will, you get to select the person to be in charge. Imagine again your know-it-all son-in-law running into court to become your administrator. You don't want to be turning in your grave. So until the court officially appoints the administrator, giving him or her the legal power to act on behalf of the estate, nothing can happen and your assets remain frozen. Sometimes people mistakenly believe that a durable power of attorney document gives them control over a decedent's assets. A durable power of attorney is used to appoint a person to act for you in financial matters when you're not able to do so because of illness or incompetence. That power of attorney is no longer valid after your death, and the person you named as your agent is no longer entitled to access or manage your assets. When I explained this to a client once, he actually asked me why anyone needed to know that his father was dead. I said, it's the law. And he said, yeah, but how are they going to know? So I'm just telling you that they will find out. Don't think that if you hold a power of attorney for someone, you can get away with pretending that that person isn't dead. Okay, I'm finished talking about intestacy, and now I'm going to talk about what happens when you die and you do have a will. Just because you have a will, though, it's not the end of the story. First, you've named in your will a responsible, trustworthy person to be in charge of your estate as executor. Let that person know where you've put your will and your other important papers, including your beneficiary designation forms, the forms you're required to fill out for IRAs and insurance companies. That way people won't waste their time having to hunt for these documents. And don't put your will in a safe deposit box because your family will have to get a court order to open the box and retrieve the will. Your executor with your original will in hand can now get assistance from a qualified attorney to submit the will and paperwork to the court in your county. The court now probates the will, decides whether to probate the will, and that means we call it proving the will. They have to decide whether the will is legitimate and valid. This is a critical step because if the court decides that your will is not valid, your property is going to pass by the law of intestacy under the state's one-size-fits-all formula. Before the court makes a decision, All of the relatives that your estate has chosen to inherit if you don't have a will have to be notified, and they also receive a copy of your will to read. If any of these relatives aren't happy with what it says, they have an opportunity to challenge the validity of your will. If one of them does so and succeeds, your will gets thrown out. And this is obviously a terrible outcome if you have a will. Now your estate has all the problems that occur when someone dies without a will. Here's an example of how it could happen. Think of the grandparent in my example earlier, who may disapprove of your live-in boyfriend or girlfriend and stands to inherit everything you have if your will is found to be invalid. If you and your grandparent are estranged and he or she needs the money, they have an incentive to try to convince the court that your will is invalid. So this is why you need a properly drafted, witnessed, and executed will, so that no one can succeed in challenging its validity. If no one challenges the will and the court finds that the will is properly drafted and executed, it will accept the will as authentic and legally valid. At that point, the court issues certificates to your executor called letters testamentary in New York that give your executor the legal power to collect your assets and carry out the instructions in your will. If the court declines your will, your property will pass an intestacy to the relative selected by your state's one-size-fits-all formula. Once the executor has received the certificate from the court, he or she has legal authority to begin the task of administering your estate, which includes finding and collecting your assets, paying your outstanding bills, funeral expenses, personal taxes, and the taxes of your estate and the expenses of administering your estate. Finally, the executor will distribute your property to your beneficiaries according to the instructions in your will. Your estate pays the executor to perform these tasks. The fee for an executor or administrator is determined by state law based on the size of your estate. The executor has to account to your beneficiaries to show that your assets were properly managed and distributed. Without a will, the administrator appointed by the court performs these tasks. An effective will. I began telling you all the things you can accomplish with an effective will. I also told you that a will can be defective, which means not accepted as valid by the court. This can happen because a will isn't drafted properly, or there's an ambiguity, or it isn't signed and witnessed in accordance with your state's law. Here's an example of an ambiguity. Someone died with a will that said he left his residuary estate to the church that he was regularly attending at the time of his death. So after the death, two churches came forward to the court and were able to prove that the decedent regularly attended their church. In this particular case, the court decided to split the money between both churches, but the court could also have decided to throw out the will and distribute the property according to the state's law of intestacy. Here's an example of an improperly executed will, and the inflexibility of the requirements will surprise you. In New York, if it turns out that one of the witnesses who signed your will was a beneficiary under the will, then that witness doesn't count. And in New York, you must have two valid witnesses. The will witnessed by only one person could be declined by the court because of improper execution. Now, I'm giving you these details to persuade you that it's just not worth it to try to draft a will by yourself. The law is arbitrary, illogical, and very strict. Get an experienced trust and estates attorney to help you. A will doesn't have to be expensive, but it does need to be properly drafted and executed. An inadequate will can be challenged by unhappy relatives or friends who don't like the way you've chosen to distribute your assets. This can lead to conflict and litigation among family members or loved ones, and a court battle that could end up consuming all of the assets in your estate. If you have an effective will, you can have some certainty and control over what happens to your property. Without a will, you've left no one in charge, no instructions on how to distribute your property. You've left a mess. Your family and loved ones will be burdened by having to figure out what to do. They'll have to figure out what and where the assets are, who's entitled to inherit them, and how to get legal title. Without a will, the court has to appoint someone to be in charge of your estate, and it may be a person you don't like or trust, such as that unreliable son-in-law who everybody hates. And the administrator and executor get paid out of your estate to perform their job. So it's in your interest to have someone you trust named in your will so that the instructions for distributing your property actually get carried out. To summarize, a will enables you to leave instructions about who inherits your property, name a trusted person to be in charge of your estate, and name a guardian to be responsible for your minor children. If you have a taxable estate, it enables you to determine how the estate taxes will be paid. And doing an estate plan early in life may enable you to minimize the taxes. Another great benefit of a will is that it enables you to hold property in trust so that it can be distributed over time to your beneficiaries. If you have minor children, you can isolate assets for them with a trust and let your trustee know how you want him or her to spend the money for your children as they grow up. A trust under a will can also allow you to preserve assets for children from a first marriage. Or you can protect the funds for someone who's a spendthrift who wouldn't be able to use the money properly if it came all at once. You can set up a special needs trust under your will for a loved one who's receiving Medicaid or other government benefits without causing him or her to become ineligible for those benefits. You can use a trust under a will to protect someone from a bad marriage or from creditors. And if you have a pet, you can set up a pet trust for its care after you're gone. I hope I've succeeded in convincing you that a will is an important document that can provide you with a lot of flexibility in providing economic and emotional support to the people you care about. Without a will, you can't accomplish any of the things I've discussed. You've given up control of your property and your minor children, if you have any, to your state. Believe it or not, creating a will can be a positive, life-affirming experience, enabling you to provide for the people you care about after you're gone. So if there are any questions, I think you can send an email to Maggie.
Yes, you can send it to info@savvyladies.org, or you can type it into the chat box here. And we did have some questions that came in during your presentation, so I'll start with this first one here, which is, I don't think I can afford to pay an attorney right now, but I do need a will. Do you think LegalZoom is an appropriate alternative?
You know, you may be able to find that there are pro bono lawyers, that there's some kind of pro bono group. That means lawyers that will do the work and not charge anything in your area. And I really recommend that you try to go to them, because even if LegalZoom or whatever the company you're thinking of using is able to print out a document that's mainly correct, there's so many little things that if you sign incorrectly, if you don't witness it correctly, or if you don't say the right words because there's a little ceremony, that it can enable the will to be challenged and invalidated. So I suggest that if you possibly can, you try to get an attorney.
Okay, thank you. And the next question we had come in is, how much does it cost to set up a will?
Okay, well, I mean, there's a range, and you may have to shop around if you're looking for someone to do a very reasonable will. But, you know, wills can cost, I mean, of course, everything in New York costs more than anywhere else, but I would say that the range is from, you know, 500 to over 5,000.
Okay. And also the follow-up to that question is about, do you or does your firm provide services to residents of New Jersey, or do you work outside of New York?
I work in nearby areas, so I do sometimes do work for New Jersey. But
Okay.
as you realize from my talk, that the wills are state, they're governed by state law. So in general, it's best to have someone from your state drafting your will.
Yes. Okay, great. And another question is, I've heard of different wills like a living will and a last will. Can you talk a little bit about the differences?
Yes, a living will is something that tells uh, people what you want to have happen when you are so ill that you're not conscious anymore, whether you want to have life support or that type of thing. It's a totally separate document than a will, which provides for how you're going to give your property to your beneficiaries. So I'm glad that that came up. A living will is something that, in addition to a healthcare proxy, can let you say that you don't want to be kept alive if you're in a vegetative state.
Okay, thanks. And another question is an example of someone living paycheck to paycheck and the only real asset is a car. So, is there a minimum amount you need for assets to set up a will? Or would you do it if you only have, for example, a car?
Well, if you want that car to go to a specific person, then you need a will. But if you don't care about where the car goes, then you don't. If you have no assets that you care about giving to somebody, then you don't need a will. It's really, the will is to take care of assets and appointing guardians and that type of thing.
Okay, thanks. And next question is, can you leave one house to multiple people? And then do they then decide how it will be split or managed?
Yes, you can leave a house to multiple people, but if those people aren't likely to get along, it might be a better idea to sell the house or enable one of them to buy the house from the estate and then split the proceeds among everybody.
Okay, great. Well, those were all the questions we had. So I want to thank you, Sue, for an excellent presentation. And I want to thank everyone who joined us today. We hope you'll join us again. And thanks again so much, Sue. It was great.
Thank you.
Bye bye.
Bye.